Hey there, happy Thursday. Bill O'Leary here again on our Thirsty Thursday series. Again, every Thursday, I'm going to come to you at this time talking about a topic of interest relating to whether it's elder law, estate planning, maybe some probate, post-death administration. So if you're thirsting for knowledge, you come to the right place. So today's topic is how does estate planning for blended families work, for blended families? So look, as if financial decisions aren't challenging enough during your lifetime, they can sometimes become even more complicated when you die. This is particularly true when relationships may develop or emerge later in life, and you decide to enter into a second marriage, what we call a blended family. And so, estate planning for blended families it's certainly more involved. Even though it's more involved, though, it's not insurmountable. So where do you begin, and what do you need to know? Blending two families, from the emotional considerations that are present to the actual physical space where everyone's going to live, sometimes is a difficult balancing act. And you add to this the financial sort of the trifecta of what's yours is yours, what's mine is mine, and what's ours is ours. And sometimes that then creates a breeding ground for challenges or disputes. Look, blending a family is all encompassing. It sounds really simple, but it's really complex, and it's fraught with potential pitfalls that you really need to steer yourself properly around. One tricky area that blended families really often encounter is in the area of estate planning, which really has the potential to create mistrust and maybe some discord, if you will, among family members if it's not handled properly. So not only are the issues with blended families in second marriages more complex, but the emotional issues around those decisions sometimes are more intense, especially when dealing with the competing interest of your children, stepchildren, and a new spouse. But I will tell you, the number one key is communication and preparation. Communication and preparation are the two most important things that frankly are often missing where families are struggling to blend two families together. Successful blended families take seriously the need for spending a lot of time talking about these potential issues, talking about feelings, talking about conflicts, so that the issues are aired out up front and plans or agreements are put in place. Sometimes it's a dilemma for some families. How do you educate new family members while at the same time, being reasonably cautious about sharing information? So first, I'd like to share with you what I consider to be three tips for blended families in a way that's going to maintain family harmony. Tip number one, identify the people to be named. Every estate planning should begin with a list of people that you want named in your planning documents. For example, people to serve as your agents or your decision makers if you become incapacitated, or the decision makers when you die, or maybe the people who you want to receive your assets and possessions. So again, identify the people to be named, tip number one. Tip number two, outline the bequest amounts. Outline or describe the amounts that you want to give. Consider the amounts you want to give to each person. Amounts should take into account the financial needs, particularly for surviving spouses, as well as young children and dependents. Also, keep in mind, very important, keep in mind how the assets will go if, let's say, you have a prenuptial agreement or a postnuptial agreement or a divorce decree. Okay? So that's tip number two. Tip number three, evaluate the goals relative to the assets. Determine how realistic your wishes are in relation to your available assets. And this is especially important in a second marriage or blended family and in dealing with that kind of planning. It's not uncommon. Look, it's not uncommon for assets to fall short of what's hoped for or even what's necessary for the family goals, which sometimes can result in a funding deficiency, in insufficient amount of money going to where you want it to go. In these situations, actually, life insurance often is a great solution to sort of fill the gap or to equalize things. Okay, so those are sort of the three tips. Now I want to take a few minutes and talk about what are some of the common blended family sort of estate planning techniques and discussion topics. Once you get you've gotten with those three tips sort of a 30,000-foot overview and understanding, it's a good idea to talk then to an estate planning attorney and a financial advisor to map things out. These professionals can help you understand some of the common techniques that are used in second marriage planning. So, for example, an important decision to make is the question of outright ownership versus a trust for the surviving spouse. Upon the death of the first spouse, there are two main ways that assets might flow for the benefit of the surviving spouse. One is what's called outright ownership. So it's just where the assets are transferred outright to a spouse. This certainly is the simplest, the least complicated approach because no trusts are involved. However, the ultimate disposition of the assets, becomes subject to the surviving spouse's estate planning decisions. For example, the surviving spouse, despite his or her promises to split things between both sets of kids, might change their mind and give everything that both of you have worked so hard for, might give everything to their own kids, cutting out your kids, cutting out the kids of the first deceased spouse. Couples in a second marriage need to consider the trade-off between simplicity versus forfeiting the ability to control or dictate where the assets will go after the second spouse's death, including being able to protect the children's interests, the children of the first spouse to die. In fact, this is where couples in a second marriage often fall flat on their face when it comes to their estate planning. Many couples in second marriages have simple wills, what I like to call I love you wills, which simply say, look, honey, when I die, everything goes to you, and when you die, well, everything will come to me. These simple wills, although simple, simply don't cut it for couples in second marriages, especially where one or both of them has children from a prior marriage. Couples in a second marriage need a revocable living trust instead of just having those simple wills. And a trust is a much better solution than just having these simple wills. A trust can solve many of the nightmares that frankly come home to roost after the death of the first spouse in a blended family. So again, an outright distribution is one way. The other way is to use a trust. So that way, instead of everything going to the surviving spouse as an outright distribution, where again the surviving spouse can change things up and cut out the children of the first deceased spouse, another option is for everything to go into a trust for the surviving spouse. That way, the trust can be there for the surviving spouse for the rest of his or her life, but it can also last beyond the surviving spouse's life, where at least some of the trust assets will be available to go back to the children from the first deceased spouse. Okay. There are two main types of trust that can be set up for a surviving spouse. The first is what we call a marital trust. This is frequently recommended for blended family estate planning because it allows assets to be made available to the surviving spouse during the rest of their lifetime, while at the same time also it dictates how the residual funds in the trust will be distributed upon the surviving spouse's death. This allows the first spouse to die to ensure that all of the remaining funds will flow back to his children or her children, or at least are split between the children and stepchildren. This is a key consideration in blended families. So we just talked about a marital trust. Another trust is called a family trust, and some of you may have heard of that, a family trust. This is the kind of trust that typically holds money, okay? But it's going to not only benefit the surviving spouse, but it's also going to benefit the first deceased spouse's kids all at the same time. They're all beneficiaries of the trust at the same time, rather than with the marital trust, where the surviving spouse is the only beneficiary, and then the kids have to wait till the surviving spouse dies. With a family trust, the kids can be beneficiaries at the same time, with the surviving spouse. So think of this as sort of creating a sort of a commingled pool of assets. And this structure might allow, the children to benefit from the assets, again, while the surviving spouse is still alive, rather than waiting until they die. So this type of trust, again, called a family trust, sometimes can raise complications regarding the use and the priority of trust assets between the different sets of beneficiaries. In other words, potentially setting up a tension between the second spouse and the kids from the first marriage, a tension over who gets what from the trust. So careful planning and thoughtful drafting are required, okay? Home ownership. Let me talk about home ownership. If both spouses own their home as what's called joint tenants with right of survivorship, or sometimes known as tenancy by the entirety, the full value of that house will transfer to the surviving spouse. This means the house will be 100% owned by the surviving spouse, who then will be able to give the house to his or her kids and cut out the first spouse's kids, the first spouse that passed away. In other words, the final disposition of the house will be decided by the surviving spouse's estate planning documents. Now, on the other hand, if one of the spouses owns the house they live in their individual name, it will transfer as they may direct or dictate in their own estate planning documents, okay? Possibly not making the house available to the surviving spouse. So if you're not comfortable with either of these scenarios I've just talked about, it might be wise to consider ownership changes and leaving the house in a trust for the benefit of the surviving spouse, but where the surviving spouse can't pull the rug out, okay? Another sort of technique or thing to consider is immediate bequest to the children. Look, how to support your surviving spouse after you die without slighting your children can be a sensitive topic for blended families. Making an immediate gift or bequest at your death to your children from your prior marriage can help acknowledge their importance to you. And these immediate bequests can be made outright or can be held in a trust that will last on for your kids, depending on your personal wishes. And these immediate bequests would go first before the other assets go to the surviving spouse. So that's another planning consideration. How about who to select as your trustee? If assets are held in a trust, I strongly recommend careful consideration of sort of post-death family interactions. In particular, who should you consider how the, or should you consider how the trust beneficiaries will respond to the trustee? Careful selection by you of the trustee is important. You should think about how all the parties may interact together, especially during the emotional period of bereavement and even later as the beneficiaries get older. How about considering beneficiary designation changes? Couples in a blended family frequently need to make changes to their beneficiary designations. Just as a reminder now, the named beneficiary designations always supersede any plans that are in your will or in your trust agreements. How about being thoughtful about your tangible property, your personal belongings? They might be the least valuable assets in your estate, but they often carry significant sentimental and emotional value. If your belongings are intermingled with your spouse's and you have children or stepchildren, it's important to dictate specific bequest, specific things going to specific people, either as part of your estate planning documents or perhaps in a supplemental memorandum. And then lastly, the consideration of communication. Communication. Look, the most successful estate plans incorporate strong legal documents alongside open and frank communication. This is especially important in blended families. Advanced discussions with children, stepchildren, or other heirs can avoid surprises, or worse than that, maybe hurt feelings. And they can also help, ensure a successful transition of assets for surviving spouses, as well as the remaining family members. Okay. So if you'd like to know more about how does estate planning for blended families work, and maybe how we can help, we'd be more than happy to talk to you. You can book a free 15-minute phone call with our team. Just go to our main Facebook page for Legacy Planning Law Group and select the Book Now button, and this will give you the chance to tell us what your concerns might be and what your situation is. And the phone call would also give us both a chance to see whether we'd be a good fit for each other. Again, this call is complimentary. Or perhaps you don't want to book the call on Facebook and you'd rather just call the office directly. Well, that's fine too. The number is 904 880 5554, or you can just Google us, Legacy Planning Law Group. So I hope you've enjoyed this talk on how does estate planning for blended families work. I plan to give another Facebook Live talk again next Thursday afternoon at the same time as part of our Thirsty Thursday series. Same day and time, different topic. So again, if you're thirsting for knowledge, we will quench your thirst. So this is Bill O'Leary again signing off for now, and on behalf of the entire team here at Legacy Planning Law Group, what I affectionately call Team Legacy, want to thank you for spending part of your Thursday afternoon with us, and go make it a great day.